All right, good afternoon, everyone. Good afternoon, Commissioner Hayward. We're going to go ahead and get started. Ms. Linker, would you care to call the roll, please?
Commissioner Hayward?
Here.
Chair Matich?
Here. All right, we'll proceed to item number 1. That's public comment for items not on the agenda today. Do we have any public comment for items not appearing on today's agenda? Hearing and seeing none, we'll proceed to item number 2. It's approval of the April 20th, 2020 Law and Policy Committee meeting minutes. Commissioner Hayward, do you have any changes, edits, comments on the meeting minutes?
No, but I think we're approving the May minutes, not the April minutes.
Yes, we are. I'm reading from the May minutes, so that's my apologies. Correct. We are approving the May 7th, 2020 Law and Policy Committee meeting minutes.
Time flies when you're under quarantine.
Yes. All right. Do we have any public comment on item number 2? Hearing and seeing none, do we have a motion to approve?
So moved.
All right. Second, Ms. Linker.
Commissioner Hayward?
Yes.
Chair Matich?
Yes.
The motion passes.
Excellent. We'll proceed to item number 3, and this is our continuing behested payment discussion. We did receive a comment letter from the Olson-Remshow firm with respect to behested payments, and we also received an email comment from Kim Cooper. I believe those are the extent of the written comments we received ahead of.
There's a Jim Sutton comment too. Excuse me. There's a Jim Sutton comment too.
Correct, and we did receive the comment letter from Mr. Sutton following our May meeting, and so that should be added to the public comment record.
Yes.
All right, Mr. Bainbridge or Council Harrison, who wishes to take up this issue with us today? And perhaps if you could start by just reporting back on, to the extent that we've had additional outreach efforts, and just get us up to speed on where we're at with that.
Good afternoon. Karen Harrison, Senior Commission Counsel. We are continuing the process of basically the interested persons meeting of gathering input from regulated community, from nonprofits. We have reached out specifically to a number of nonprofits and asked for comment. We have received some comments back that this is a crisis time for them, and they've requested that we develop a schedule or delay the process so that they can participate. So that's one comment that we received back from a number of people. We've also reached out to local ethics organizations, and we'll be having a roundtable meeting, I believe June 15th, with a number of local entities involved. We have reached out and discussed behested payment reporting issues with the Council for the State Assembly and Senate to listen to the issues that they're experiencing, specifically with electronic reporting, as well as a general topic. We have sent out invitations to local officials to ask for their input or for their agents who file these reports to let us know how that's working for them. We're also pursuing, researching other state laws where behested payments have a treatment. They don't call it behested payments in other states, but they have, there's several states, Florida, Hawaii, Louisiana, New York, Rhode Island, that have a similar type of behested payment reporting situation or prohibitions. We're looking at local practices for San Francisco and Los Angeles, as well as reviewing past enforcement decisions. There's only a few that have involved behested payment reporting. And then once we complete that part of the process, then we anticipate moving forward with some direction from law and policy as to the next steps.
Great, thank you. Mr. Bainbridge, do you have anything to add to the update we just received from Senior Counsel Harrison?
No, I think Ms. Harrison covered it.
Great. Couple questions. First, I noticed that Mr. Sutton included a reference to San Diego, I think their city lobbyist ordinance. as potential fodder for us to look at as we consider issues with behested payments. Is San Diego Ethics among the institutions you'll be talking with at that roundtable?
Yes, they will be joining us. We've got commitments from the biggest ethics agencies in the state. I think all the ones at least that have enforcement mechanisms. So I understand San Diego will be there as well.
All right, great. And then I know you mentioned that you're looking at other states' laws and also how other local jurisdictions approach behested payments, similar issues. Just your initial impression, I'm curious, where do we stand with respect to our regulations in the state law? Are we on the more stringent side? Are we less stringent than other states and local governments? Kind of, can you compare for us, give us a sense, where do we stand?
I would say that in comparison with San Francisco, for example, that they are more stringent than our requirements, which they're allowed to do. I'm just now getting reports back from some of the states, so I've looked at New York, and my comment right now would be that it's different. Every state handles this differently. Kentucky, for example, is probably at the other end of the spectrum from where California is in terms of regulations. It seems to be a mixed bag. Washington, for example, doesn't seem to have the same kind of prohibition, but they have a time period prohibition. So I'll do a summary report as I get that information.
Great, thank you. Commissioner Hayward, did you have comments or questions for staff?
No, I'm really happy to hear of the work that's been done. So I'm looking forward to seeing how that gets compiled for us at a later time. I once again want to say that I'm sympathetic to Jim Sutton's frustration in this area. I think the Olson letter paints a slightly rosier picture of the behested payments reporting system than is experienced by a lot of clients of other private lawyers, including, I guess, apparently Mr. Sutton's clients. And the way he describes the interpretation he would prefer, I'm largely sympathetic to, but it's just that our statute doesn't require that we find that there's a purpose to influence behind the gift. All we look for is the ask, right? And so I can see maybe in some hypothetical suit somewhere, some court saying we've got to construe this more narrowly because it's overbroad, but that hasn't happened. And we have the statute that we have. And so again, I'm sympathetic to Jim Sutton's point of view, but I think that ultimately it doesn't help us that much because he's talking about a law that's significantly different from the law that we have before us.
Great. Thank you. I had another question, and the question was prompted by some of the statements in the Olson-Remshow letter that we received. Sort of paraphrasing portions of the letter, well, I'll just read it. Under the heading of behested payments with a personal benefit, and I know, Commissioner Hayward, this is something that you've talked about before, the concern being that behests are being used for the personal benefit of elected officials, and how can we perhaps refine our approach to that? The Olson-Remshow firm writes that the Commission essentially has the ability to address this under current law through its enforcement process. And my question is from the standpoint of our enforcement staff and enforcement division, do you agree or disagree with that? And if you believe that additional refinement is necessary, what specifically would you recommend that we give consideration to? I see Ms. West has joined us, so she's probably the best to answer that. Good afternoon.
Hello, good afternoon. Can you hear me?
Yes.
Okay, good. So I've thought a lot about this because I presented in November behested payments being an issue and something that enforcement was looking into, trying to get some regulatory guidance, and then also perhaps amending the streamline program to add behested payments. And at that time, the Commission expressed an interest in looking into not just personal benefit, but also perceived personal benefit. And so I definitely believe that the current law doesn't address that. It's if we want to start looking into aggravating factors of perceived personal benefit as well as regular personal benefit, that would be something that we would need to put in the regulations, I would think. And then also, as it stands now, personal benefit is difficult. It's a gift standard that isn't really defined anywhere. And so trying to apply it is basically looking at advice letters and applying them. And some of the advice letters have said inaugural events are okay, and having the expenses for moving into your office and all of that are okay to be paid. And the whole landscape has really changed, because now we're talking about these entities that were created to benefit the public official in whatever endeavor that is being facilitated. So it seems like these advice letters that we're applying to maybe shouldn't be the written rule of law on this, and they should be more the examples that they are, and not the only thing that we can go on. Because another advice letter is the one that talks about whether or not the funds were earmarked for the person's benefit or overhead for the nonprofit that the public official works for. And it has an idea that money is infungible. And so you have all of these and you combine them all together, and that's how you make a determination on pursuing a case or not. And I don't really think that's the way that we wanted to be approaching these. We would like a little more guidance and maybe a fact sheet approved by the commission, or at least something that kind of says where we're at, where these advice letters stand, and where they stand in this new regime of creating these entities.
Great. Thank you, Ms. West. Mr. Bainbridge, did you, or Senior Counsel Harrison, did you have anything further or comments on what you heard from Ms. West?
No, just to say, to be clear, when we talk about personal benefit, we're talking about the definition of a gift. So that term isn't defined in the Act. It's just if something provides a personal benefit, it's a gift, and then so it will be treated as such instead of as a Hester payment, to frame the issue for everybody that we're talking about. And there's years and years and years of advice letters where it's a specific situation asking about a personal benefit, and so it's a very fact-specific analysis, and I appreciate the struggle in trying to apply that in situations of enforcement, trying to figure out what that term means. I also I think it probably hasn't been defined yet, because no one could maybe figure out how to define something that could be so broadly applied without potentially creating a bigger mess than just having a term that's hard to define. But I think that's the crux of the issue, is what do we consider a personal benefit that would then create a gift as opposed to a vested payment.
Ms. Harrison, would you care to add anything?
I think that I would just add that in terms of enforcement, there's a lot of caution, because vested payments are this third category that have been carved out from what used to be contributions subject to limits reporting, or gifts subject to limits and reporting. And so I think one of the things that I did see in looking at other state laws is that they haven't created this third category. And so these payments are seen within that context of limited contributions or limited gifts. And so once you get in the realm of behested payments, I think it's a good idea to be careful that it not become a mechanism to skirt contribution limits or gift limits. And I think that Ms. West is correct. Looking back on advice letters, that was perhaps a different landscape than where we are now in terms of nonprofits that are being created, perhaps to skirt those limits.
Just following up on that point, have we looked at, or do we have any data to support the idea that nonprofits are being used perhaps more frequently now, or more recently than they were used in the past, following the creation of the vested payments in statute?
I don't have concrete data on that, no.
Right. Is that something that we think that we could, I hear your concern on that, and I wonder whether we could look at that and see whether there's data to support that or not. Is that something you think we could do?
I can certainly look. There are there are some sources that I can look to see if we have those types of numbers available.
Okay, I think that'd be helpful, just to at least just have the data in front of us. I had another question. So we've talked about personal benefit. Another issue that I've heard with respect to Hester Payments is instances of non-reporting. So a circumstance would occur where it should be reported as behest, but it's not being reported. And so I guess, again, Ms. West, first to you, from an enforcement standpoint, if the problem is non-reporting, how in the world does enforcement approach that? Because how would you know if something is a behest and hasn't been reported that non-compliance is occurring?
That's interesting. Actually, as this becomes more known by the public, we're getting actual complaints of people not reporting. So it's all about educating the public. So the more that the public knows, the more they will recognize, oh, this was a solicitation. This was something that was sent out, and I don't see any behest payment reports. And sometimes that's because it doesn't reach the $5,000 threshold. But I think that it is becoming more prevalent, and we are seeing that when someone makes big outreach, that the local public is starting to notice, and they're looking for these reports, and it's becoming more of a known thing. The other way that it can be discovered is that the same way that we discover gifts over the limits. So occasionally in our spare time, we reach out to different organizations and ask them who they have given to. And we would do the same thing where we would ask them about solicitations. In fact, we did it a couple of years ago, I think with Walmart, where we were asking them about certain donations that they had made and asked if they had been solicited by anyone. And so there are ways to do this proactively, and there's ways to enforce it. Obviously, it's one of our multiple proactive programs that we integrate into our workload.
Great, thank you. And then actually I did, Ms. West, have a follow-up question for you. You mentioned the concept, going back to personal benefit. I think you used the phrase perceived personal benefit. Can you explain that a little bit more? I want to make sure I understand what you're talking about when you're talking about a perceived personal benefit.
I think Commissioner Hayward's actually the best person to answer this question, because it was a term from the commission meeting that we had talked about behested payment cases. And the commission was talking about when there's a personal benefit, obviously that's the worst, and we got to talk about whether or not that's a gift. But then there's this also idea of perceived personal benefit, going off what Ms. Harrison was saying, that it's not just about what these are, these behested payment, weird third child kind of ideas. They're not contributions, they're not gifts. So they're not subject to limits, they're only subject to this disclosure. And so when you have a perceived personal benefit where it's your family member or some other person working for the organization, then it felt worse to the commission, that should be something that we're considering and saying, it shouldn't just be, because it's about perceived conflicts and conflicts. It should also be about perceived personal benefit and personal benefit. But Commissioner Hayward, I don't know if I articulated that well enough.
No, that was fine. I think what we were trying to get at is, again, people using behested payments to circumvent the serious gift limits. And now as of January 2021, the statewide state and local contribution limits. And as there are more contribution limits in places that people aren't used to them, there are going to be more interest in workarounds. And so you're going to look at solicitations for, what is it, governmental, legislative, or charitable purpose, the behest is. And that governmental purpose could look like doing something really nice for the elected official, who after all is part of the government. That's a governmental purpose, kind of, but it's also a personal benefit thing. And I don't have like the regulatory language I want right now. I think this is an appropriate avenue of inquiry, though. And because it seems to me a really juicy opportunity for circumvention, and if we can anticipate that a little bit, I think we'll be happier when the contribution limits are implemented to state and local races.
And I would add to that, that it was brought up specifically in the terms of family members and including in the definition of this personal benefit or perceived personal benefit more than just your immediate family, or the benefit is extended to those around you.
Great, thank you. Ms. Harrison, do you have anything further before we open it up for public comment? All right, great. Well, thank you very much for your continuing work on this. At this time, we'll go ahead and open it up for public comment. First, we'll take public comment on the phone. Do we have any telephone public comment on this item?
This is Ashley Titus from Bell McAndrews and Hilltack.
Good afternoon.
Hello. So I have two general comments. First, I don't know how many years it's been now, but when the gift regulations were being overhauled, one of the items on the punch list that never was completed was defining personal benefit. And it would seem that taking that on now might resolve some of this ambiguity over what's a gift versus what's not a gift. The second comment I have is in response to an issue that was raised in the Olson letter, where it discusses consenting to be featured, and if that's a behest, and I've actually had this come up recently, where it's not the elected official who has asked a private funder to pay for something, but rather the other way around, where a private funder has asked a public official to say be in an interview that they're then going to post on their website about a public policy or civics issue, you know, maybe COVID testing and where to go, or what the government is doing to respond to that, or, you know, those sorts of examples. So there is a payment, I suppose, but it's not necessarily behested by the elected official. And is a report required under those circumstances? So it seems there needs to be some thought to a fourth bucket, and that is, when is there a payment that's really a nothing? It's not reportable. It's not a contribution, it's not a gift, and it's not a behested payment.
All right. Thank you, Ms. Titus. On that last point, Ms. Titus, I just want to make sure I understand clearly what your point is. Your point is where instead of an elected official, as many of them have done recently, maybe soliciting themselves contributions to a charitable organization, let's say related to the pandemic, instead a charitable organization approaches one or several public officials and is asking to use their likeness in a solicitation. And the question is whether, when that scenario occurs, whether there's a reportable behest. Is that correct?
No, actually, there is no use of a likeness to solicit at all. So say a 501c organization wants to interview the public official and post that interview on their website where they're discussing maybe a local community issue, public policy issue, their thoughts on policy. There's no ask for money. There's no solicitation by the organization to donate to the organization using the public official's likeness, but there's a payment involved with producing the video interview and then posting it on a website or promoting it in social media. Okay. But no donation is behested by the organization or the elected official in that case. The payment is only the production and dissemination of the communication featuring the official.
Okay, thank you.
So is the official's mere agreement to be interviewed a behested payment?
Okay, all right, thank you. I think I understand your question now. Ms. Harrison, I hate to put you on the spot, but let me just ask, off the top of your head, do you think that scenario would trigger a behested payment reporting obligation under our rules.
This is Dave Bainbridge. I don't think we should be getting into vague scenarios like that right now. I mean, if there's an issue, we can consider it, but I think it's unfair to ask Ms. Hester to help with that answer off the top of her head right now.
Well, with respect, Mr. Bainbridge, I mean, we understand the regs, and I'm curious, based on the regs as they exist, has this ever come up, and have we thought about it? And if the answer is, we haven't thought about it, or we'd have to go back and look, I think that's fine. But if you do have a off the top of your head preliminary thought on it, I would appreciate your indulgence. Ms. Harrison.
I'm sorry, Mr. Bainbridge, did you want me to respond, or did you want to respond?
He asked you the question. If you feel like you can answer it, yes, but if not, why don't we go back and take a look at it and we can come back with it later.
And that's fine. It's only if you have.
Okay. I think my only comment would be to go back to the definition.
I think somebody needs to mute their line. We're getting some background noise there.
So I think I would just go back to the definition of made at the behest of, and take a look when you're talking about payment, who's making the payment to whom and who's making the behest. So I would say go back to those definitions and look at that, and then I think that we can come up with an informal response.
Okay, great. Thank you, Ms. Harrison. I appreciate that. Do we have any additional public comment on the phone line?
Hello?
Hello?
Yeah, my name is Rob Kwan with Unrig LA. I wanted to give some public comment on this.
Please.
So yeah, I as you might have noticed, our city of LA has made a lot of headlines for the wrong reasons recently. Blatant bribery allegations, troubling stuff, but it's kind of overshadowed some of the stuff that trickled out early in the investigation involving behested payments. With Councilmember Weezar, he of course never filed a single behested payment, even though he was raising money for his old high school in the $5,000-$10,000 range plus, and his wife was even serving as a paid fundraiser for the school, which provides an additional layer of concern. My comments were specifically about that perspective and advocating for the last year on this issue. The disclosure threshold and issue of compliance is a big one. Like 6 years ago or so, there was a recommendation to lower our disclosure threshold to 1,000, and they passed on that. I noticed last year that 2/3 of our city council members had never filed a single behested payment. It was really weird to be advocating in front of these council offices and hearing their staff complain about filling out forms and finding out that their office had never actually filed an 803. And in the discussion amongst our council members, and even when we met with them, really revealed a complete confusion on what is and isn't a behested payment. And in part, them not necessarily doing their homework, but there really isn't like a whole lot as far as educational materials. Even though we have a great ethics commission here, they don't necessarily have the resources. They only recently got an education position back. They had 2 before the recession in 2008. So we really don't have much to offer them. I looked at the FPPC website, and there's not much there. I kind of found myself parsing through a bunch of advice letters from decades past. So I just say, I know that these things are kind of in flux, but the biggest thing that's needed is a whole lot more guidance for people inside and outside of government on what is and isn't a behested payment. Specifically, LA City Council turned down the opportunity to enact some really bold reforms, like building upon a $1,000 disclosure threshold. I'm sure you've spoken with their staff. They had a proposal that we supported at the time, restrict behested payments from restricted sources. lobbyists, contractors, developers, et cetera. And honestly, I would say about that, just going through the process, giving everything an objective, fair shake, listening to our elected officials, in particular, some of those that, come from lower income neighborhoods and really do need to find resources for the community. I do think that what we were originally looking for last year in the city of LA from the Ethics Commission and our coalition was probably a bit too much, just because, there's so much that's not reported. And that was the biggest thing that drove my perspective on that. Like, if we can't really gauge how bad the problem is, then let's be a little cautious and completely banning the Hester payments from restricted sources. And even then, there were a number of exceptions the Ethics Commission provided. I think it's worth looking back to that as a model. But there are a number of options here that we could go beyond. But at a minimum, we really need a $1,000 disclosure threshold. There's just way too much that happens above that. It offers administrative clarity. We've got other jurisdictions in California with a $1,000 disclosure threshold. I think that should be, a solid step forward. Councilmembers Krikorian and Koretz, introduced a motion in December when they were discussing this as a full council to lower the disclosure threshold to 1,000, and that's gotten no consideration from our council. Even though we are going through a number of different FBI investigations into corruption at City Hall, they haven't really stepped up when it comes to reform. So thank you for your time and consideration of this issue, and look forward to seeing what comes of it.
Great. Thank you for commenting and making the time to speak with us today.
Appreciate it. Have a good one.
All right. Do we have any additional public comment on the phone lines on behested payments?
This is Ali Abdoli with Nielsen Merckxmer.
Good afternoon.
Hello. Hi. I just wanted to echo Ashley's first point about the personal benefit, especially when you might be considering expanding it to perceived benefits. I think it'd be very helpful to start with, some kind of definition or guidance on that specific term, preferably a regulation.
Great. Thank you very much. Any additional public comment on behested payments at this time? Hearing none, we will continue the work then of examining this issue, and I'm sure be considering this again in the future through law and policy. Commissioner Hayward, anything additional you wanted to add before we move on to the next item?
Just real quick, the remark that that Karen made earlier about having contacted nonprofits and getting the message back that this is a time of crisis and they really didn't have the ability to join with us right now. I mean, I understand that. I do, and I don't want to sound like a broken record. I am concerned about us making some progress on this before the contribution limits are applied much more broadly in January 2021, because I think people are going to need more guidance, and we're going to see a lot of people enter the contribution limit land that haven't been there before. And so while time is not of the essence, and this isn't an emergency regulation, it still is. I think it's timely for us to work on it this year.
Great. Thank you, Commissioner Hayward. And again, thank you to staff, Mr. Bainbridge, Ms. West, for all of your work on this issue. Appreciate it. All right, moving on to item number 4. This is our limited liability companies. And this is a proposed regulation that came to us back in April on pre-notice to the full commission, and also came to law and policy back in April. So this has been out there for a while. So before we consider this, in anticipation of considering this for adoption in June, as we discussed back in April, we wanted to bring this to law and policy to gather some additional public comment, if any, and to consider what recommendation, if any, we would give to the full commission. So I know we have Commission Counsel Torrin Lewis with us today, who I think I understand from Mr. Bainbridge. Mr. Lewis, you will be leading the charge on this one.
Hi there, Mr. Chair. Yes, I can give a brief overview if you like. I didn't have any specific remarks prepared. I'm also happy to just answer questions. But
well, perhaps if you could just begin by telling us what changes, if any, were made to the proposed regulation between the April meeting and today's law and policy meeting.
Sure. So specifically, what we have done is following the April law and policy meeting at your direction and Commissioner Hayward, staff has added a subdivision D to proposed regulation 1842110, and that's reporting contributions from limited liability companies. And what that subdivision D would do is provide that a contribution lacking the name information required by 1842110 subdivisions A through C shall be returned within 60 days. And that, of course, is pursuant to existing section 85700 of the Act and regulation 18570. And if you'll recall, that was also following a discussion of a public comment made by Ashley Titus at Bell Hilltech McAndrews. And so that's the only change I believe we have made to the actual substance of the regulations following that meeting.
Great. Thank you. And then I had a question. Have we received any additional stakeholder feedback following the April meeting where we first, well, I guess either the April law and policy meeting or the April full commission meeting, both of which we discussed this proposed regulation at?
Yes, the only feedback that I am aware of is actually a letter we received yesterday from Nielsen Merksimer.
Great. Thank you, Mr. Lewis. Commissioner Hayward, did you have any questions for Mr. Lewis before we open up for public comment?
No, I think you've captured what we were trying to get in our discussion, and I'm disappointed we haven't gotten more reaction. And I anticipate that once this is on an agenda for final approval, people may decide they want to talk to us. And unfortunately, if we were doing that now, we'd know what they had to say and have a little more time to think about it. So, but that's how it goes. Even when there's not a pandemic, people wait till the last minute.
Thank you, Commissioner Hayward. I would observe that the Nielsen Merksimer letter raised a number of points, and I'm wondering if either Mr. Bainbridge or Mr. Lewis, one of the points that was raised is that by taking this regulatory action, we'd be creating I think they used the phrase, a new prohibited class of contributions or activity. Mr. Bainbridge, did you have a reaction to that or comment on that, or Mr. Lewis?
Sure, so I can start. So it's our perspective that section 81004B of the Act, actually it's not our perspective, this is what the Act requires. Section 81004B requires a responsible officer or attorney or certified CPA to sign on behalf of a major donor or IE committee. And so it's our perspective that nothing prohibits the commission from selecting who that responsible officer would be in the context of LLCs. And then in fact, narrowing that definition would be consistent with the purposes of the Act, specifically section 81002A, which requires receipts and expenditures to be fully and truthfully disclosed so that voters can be fully informed.
And I would add to that, this isn't a prohibition, it's a reporting requirement. it's not prohibiting anybody. It just is requiring additional information to actually provide the name of the individual or individuals responsible for a contribution, which is entirely consistent with the purposes of the Act.
Thank you. And just to highlight at least my understanding of the new language that we added, the provision, the 60-day return provision, that's no different than when a campaign, for example, receives a contribution and they don't receive the requisite name, occupation, employer. There is a provision in the law requiring the return of that. We're simply applying that here with respect to LLCs as well, correct?
That's correct.
Great, thank you. Commissioner Hayward, did you have anything further before we open it up to public comment here?
Not at the moment, no.
All right, great, thank you. All right, we'll go ahead and take public comment on the phone on item 4, limited liability companies.
Good afternoon, Commissioners. My name is Mike Colombo. I'm one of the authors of the letter you were just referencing from Nielsen Merksmer.
Good afternoon.
I'm an attorney with the firm. And I'm speaking today as an attorney who advises people with on issues of compliance with the Act and other laws affecting their participation in public affairs and in the political process. I'm not speaking today on behalf of any client or any other person. Thanks for the opportunity to provide comments. Before I offer some comments on the substance of the rules, I have 2 procedural concerns that I just wanted to raise with the Commission. First, the agenda for this meeting indicated that the proposed LLC regulations would be a topic of its discussion, but when the agenda and supporting materials were published last Friday, it didn't include the drafts of the regulations or the staff memo. We initially assumed this was a sign that there'd be no substantive discussion today, and to the point raised about the lack of public comment, we'd note that at the April 20 meeting, there was a representation that these regulations may not be calendared for adoption, and that representation was made in response to our concerns about proceeding with this rulemaking during the pandemic due to the restrictions that the pandemic and the rules related to it are placing on business activities, as well as the economic impacts on businesses. And we're talking about the businesses that these regulations target. However, in an abundance of caution, we inquired of staff yesterday afternoon, and we were shocked to be told that there were indeed revised regulations and a staff memo. Eventually in the afternoon, the draft regulations were published, but the staff memo was, so far as I can tell, not published until either late last night or this morning. Accordingly, we were only able to quickly prepare and submit some short comments on the draft regulations with a few hours notice and without the benefit of the staff memo. We continue to believe, as we asserted in April, that this rulemaking should be held in abeyance due to the pandemic and its effects on the huge swath of California businesses that these rules target. But barring that, we'd respectfully request that this matter, at the very least, be held over until the next Law and Policy Committee meeting due to the lack of public notice, to allow the public to consider the changes and to allow you to get the feedback that you wish to have. My second procedural concern is that our April 19 comment letter was not published, nor have we been able to see any comments submitted by others, if there are any. We note that the Commission's website does publish public comments on some matters under Commission consideration, which we believe is a valuable component of the rulemaking process, and we would respectfully request that the Commission consider publishing any public input it receives in response to this matter as well. As for substantive comments, I would have preferred to submit all my comments in writing, but forced to react to the staff memo this morning, and I apologize in advance for your time that I'm taking with this. But first, we note that the regulations do not target all entities or all businesses, but only entities that are formed as LLCs. which the staff memo concedes is a very common business entity form. In our view, the stated justifications for singling out LLCs alone are misplaced or thin. The staff memo supporting the regulations contends these regulatory changes would allow the public to be informed of the actual individuals behind an LLC's contributions to a committee, rather than simply the name of a corporate entity and its registered agent or manager. But discovery of the persons behind an entity, other than those who fund an entity's activity, is not only a vague and slippery goal, it also has little support in the purpose or text of the Political Reform Act. That seems to be why the memo repeatedly refers to the inadequacy of corporate filings under other laws. Indeed, focusing on such individuals rather than the sources of an entity's money is somewhat in tension with the entire premise of campaign finance regulation, which is to peer behind a group or its front person so it can be evaluated based on the source of its funding. Although the PRA includes reference to a responsible officer, as staff noted, it is in its provision describing who is authorized to sign an entity's report, along with an attorney and accountant. But it does not require the disclosure of their identity. Accordingly, this is a new requirement. The staff report spotlights this inconsistency. It acknowledges that the actual underlying problem here that it's trying to solve is the lack of meaningful disclosure of the sources of money of LLCs. But the whole point of these draft regulations is to force disclosure of an individual controlling an LLC instead of who funds it. Contradicting this purpose and spotlighting inconsistency with the purpose of the Act, the staff report acknowledges that even when an individual is listed in corporate filings as an LLC's manager, quote, that person is usually not the true source of an LLC's capital contributions, end quote. The memo makes clear that the issue is not with the PRA, which already requires disclosure of an entity's funding if it comes from someone else, but an alleged difficulty investigating LLCs who violate the PRA. Beyond the conclusory assertion that investigations of LLCs are, quote, extremely challenging and burdensome, there's no explanation as to exactly why the Commission's investigatory tools, including subpoenas, are inadequate, or why investigating an LLC is any more challenging than investigating entities that are not incorporated at all or organized as some other entity form. The Commission has the power to issue subpoenas and does so even without notice to the targets of those subpoenas. This is the same way that any enforcement agency operates. The memo fails to establish why investigating LLCs in general is any more difficult than investigating any other entity, even an unincorporated group. In fact, the staff memo uses a quote from a congressional report about the lack of information in corporate filings to support the regulation. But the quoted report expressly refers to corporations as well as LLCs. The staff report also spends several paragraphs on the evils of shell companies, but that is not at all unique to the LLC form and, as the report acknowledges, can serve legitimate purposes. The staff memo also includes a hyperbolic, and in my view, nutty, quote from the Center for Responsive Politics asserting that LLCs, one of the most common business forms in America and the state, are, quote, the darkest of dark money groups. The only way an LLC can avoid a disclosure that the PRA requires is by breaking the law that currently exists. Nothing in the proposed LLC regulation would make that any more true. Fundamentally, the memo's justifications, and therefore the regulations themselves, rely on a false premise. That is, that contributions from the LLCs are not actually from the LLC. Looking at statistics about disclosed contributions from LLCs, the memo claims that the true sources of LLC funds could not be determined, but it never establishes that the true sources of the funds were not the LLC itself. The sum total of the evidence in the staff memo of any problem in California unique to LLCs amounts to just 3 data points. A single analysis by a news station 3 years ago of spending in a San Diego. An issue the same station made of a contribution by one LLC 4 years ago, and 1 contribution made by 1 LLC 2 years ago. That's the sum of the factual record for the justification for these rules that's been provided to the public. In addition to these verbal comments in the staff memo published today, we submitted a letter yesterday based on only the text of the draft regulations. In conclusion, and in brief, I promise, that letter makes the following comment. The Commission appears to be seeking to use its rulemaking power to correct what it sees as a shortcoming in the California Corporations Code, rather than implementing the provisions of the Political Reform Act. There's no requirement in the PRA for LLCs or any other entity to disclose the people behind them or their responsible officer. The PRA expressly states that what information a political committee must disclose about one of its contributors, and that information does not include the responsible officer, much less state that the name of an entity itself must be clouded with the name of such an individual. And finally, the proposed regulations turn this statutorily and factually unsupported disclosure requirement into a new contribution prohibition. I say that because if you've added a new disclosure requirement that's not in the Act, and you've stated that that a committee cannot accept contributions unless that new disclosure requirement is satisfied. In all these respects, it is in our view that the Commission will be acting outside the scope of its rulemaking power if it issues these regulations. I thank you for your time and the opportunity to offer these comments.
Thank you. Do we have any additional public comment on item 4?
Hey, this is Rob Kwan. I gave a comment on the last item, and I just wanted to give a quick revision to that because I left out a little information that is kind of important to understanding the point I was making. I mentioned that 2/3 of LA City Council members had never filed a behested payment through beginning of last year. And, I started dropping that fact on, some of my council visits where I met with the staff or the member. And even one of the council members I mentioned that to laughed and turned to his chief of staff and said, "Oh, I wonder if that's one of those is me. Who files those?" Sure enough, he was one of those that hadn't filed one. And, I mentioned it at public comments a few times, and sure enough, 5 months later, when the next reporting period came, 2/3 of our council members had suddenly filed behested payments. So compliance did improve, but I think the fact that members who were on there for, all of them, nearly 5 years plus, to having never reported a behested payment to all of a sudden 2/3 of them being in compliance and reporting, quite hefty behested payments showed a little bit. And we also have reporting requirements for lobbyists where they have to report behested payments below 1,000 or above 1,000. And there are some incidents where you can see behested payments filed there above 5,000 that are never filed by a council member. So I just wanted to make that note because it didn't necessarily make it clear that there were actually behested payments that were being missed. Thank you for your time.
Great, thank you. Any additional public comment on item 4? This is limited liability companies. Hearing and seeing none. Commissioner Hayward, I'm wondering, per our custom as the committee, typically when regulations are up for adoption, we take a position oftentimes to recommend adoption of the proposed regulations to the full commission. What are your thoughts on that with respect to staff's proposed LLC regulations?
I'm comfortable recommending adoption. I think staff has done a pretty good job of finding a way where under the Act and under our regulatory power, we can do something to cast greater light on what's happening with LLCs and make it more difficult to use an LLC at the last minute to funnel illicit money into a race. And again, like a broken record, when we have contribution limits kicking in January, people will likely look for workarounds. And we're going to need a easier way of detecting aggregation from donors and what donors need to be treated as one donor. This is a small step to help in that, but I think it's a real one. So yeah, I'm completely comfortable recommending adoption.
Great, thank you. And I think, first of all, I want to compliment staff. This is something, and when we first started looking at the LLC issue, I know Mr. Lewis, others on our staff spent considerable time researching the increasing use of LLCs, why it's a problem. And I know when we began, we were talking about potential legislative proposals. Given the pandemic, we've had to pare that back and look closely at what we believe we can do legally with respect to our regulatory power. The regulation reflects that thinking and that approach, and I appreciate that. And I also think, to be clear, one of the comments we received both in writing and we heard today, to my mind, inaccurately attempted to limit the purpose that we're seeking to achieve here with our regulation. It's not, we did not set out on this task just to uncover the source of contributions into the LLCs. That is one of the purposes. The other purpose, of course, is understanding who's controlling the LLC and who's behind it, because too often when an LLC makes a contribution, there really is no adequate information as to who is behind that LLC, which is a separate and distinct issue from who's contributing and whose money is being funneled through the LLC. So actually two issues here, and I think this regulation very well serves our interest in trying to identify and make transparent who it is that's controlling and running the LLC that's participating. So again, I want to compliment staff for their work on this. I would propose that Commissioner Hayward and make a motion that we recommend adoption at the June meeting. I think we were very clear actually at the April commission meeting when this came up that this would be set for adoption in June. We're following through with that commitment. This has been out there for 2 months. The only provision that was added was a provision that we explicitly talked about adding, just to make it that much clearer for the regulated community. And frankly, I just haven't heard anything to suggest that this is going to be such a crushing burden on businesses that they couldn't find a way to identify a person on a campaign report. So with that, I would move that we recommend adoption at the June meeting.
Second.
Ms. Linker?
Commissioner Hayward?
Yes.
Chair Matich?
Yes.
The motion passes.
Thank you. Thank you again, Mr. Lewis. Great work on this.
Thanks to you both.
All right, turning to item 5, facts or frequently asked questions for committee naming requirements. Commissioner Hayward, this was your idea. I tried to encapsulate it in the agenda, but why don't you take a crack at identifying what we're looking at here?
So this came to my attention. I think it's something I've noticed before, but I really noticed when we were looking at the April 2020 consent calendar that, there were easily, I think there were roughly 5 steps where part of the violation involved something wrong with the committee's name. The committee was primarily formed and it wasn't named correctly. It had a sponsor and it didn't call that sponsor. It was a candidate committee, but they didn't put their last name on it. All these things are technically violations, and it's good to have uniform naming requirements, but I'm not sure we do the best job of taking this little slice of compliance and pointing out to people that just because you think this committee name is useful or cute or amusing or effective, you've got to tick off some boxes before that name can legitimately be the name of your committee. And I'm sure that people casually going around in politics would think it would be perfectly fine if you have like a very identifiable first name, like, I don't know, Hillary, that you could name your committee Hillary and not worry about the fact that the last name is also required. I'm not picking that example to pick on anybody. It seemed to me to be one that I think most people would find sympathetic, or at least understand. So I think what I'm looking for is maybe a staff response to, is this a good idea? Does it fill a need that you identified? It seems to me that it could be like a 1-pager that maybe just highlights a part of the naming rules that we have a quick example and a citation, or a quick example and a page number of a manual. But call to people's attention that they can't name their committees anything they want. And even more importantly, the name will change over time. If your funding balance changes, you may be a sponsored committee. If your spending activities change, you may become a primarily formed kind of committee. And I think these are things that people, especially in local politics, maybe they don't think about as carefully as they should. So that's my pitch.
Great. Thank you, Commissioner Hayward. One thing I know, I spoke briefly to General Counsel Bainbridge about this, and I think he used, because we've had several conversations, but I'm pretty sure he used the phrase a decision tree as a concept that we might want to try and embrace here. I know we have very extensive campaign manuals which provide the detailed nitty-gritty on how to comply with the PRA's requirements, but having something in the nature of a one-page decision tree to help folks in the regulated community properly name their committees in compliance with our regulations might be a worthy goal for staff to take up. Mr. Bainbridge, am I misremembering that, or? I'm trying to give you credit.
Yeah, it might look like a banyan tree, but all that information is in manuals with examples, but it's not all in one place. The Form 410, the Statement of Organization, in the instructions has a whole section on naming your committee. Obviously, if you're 3 years down the road with your general purpose committee and you might become primarily formed, that's not going to help you much at that time. So yeah, we can look into a way to put all the naming information into a single document with references to more specifics in the specific manual, because there's a manual for each type of committee.
Right.
I can't promise we can keep it under a page, but I think at the very least we could create a table of contents of sorts to route people to the right place in the manuals.
And that's really it really struck me in April that I thought a couple of the naming violations were in fact just ignorant and accidental. Nobody was trying to hide anything. Nobody was being even negligent. It's just, that's the name of my committee and I'm rolling along in life doing what I'm doing, and calling people's attention to the fact that your committee can change, I think is important, because it's it might be unexpected to people. Yeah,
and the issue, it usually comes up in the advertising context, because advertisements are wrong if committee names are wrong. So if usually you see this along with an underlying advertising violation, this would go along with it. So yeah, we will see what we can come up with that is less confusing than nothing.
I appreciate that. I think it'll help.
Great, thank you, Mr. Bainbridge. Is that something that would it be too ambitious to hope for something by the July Law and Policy meeting, or what's your sense of timing on that?
Probably, but we'll get started on it now, and maybe we'll just check in a few weeks and see where we are.
Okay, great. I appreciate that. All right, do we have any public comment before we move on to item 6? Any public comment on item 5? Hearing none, we'll move on to item number 6, campaign-related mass mailings sent at public expense, payments by state or local governments for campaign-related communications. And this is our preliminary discussion. I would characterize it as more of a conceptual discussion about possible regulatory action to strengthen regulations 18420.1 and 18901.1. And we put this on the agenda in part in reaction to the legislature not having the opportunity to take up a number of PRA-related bills that we had asked them to consider this year, one of which related to mass mailing sent at public expense. We've identified that at the Commission as an issue worthy of our attention, something that we think is a serious violation, serious breach of the public trust. And so what I wanted to do was have a brief discussion about the possibility of perhaps taking the standard for when a reportable expenditure would occur that we had proposed in the legislative package that we discussed previously, and using that as essentially taking that and adopting a regulation to codify that. So instead of going through the legislative process, we would do that by regulation. I believe that is clearly within our authority, and the purpose would be to clarify the standard for the benefit of the regulated community, local governments in particular. So that's my pitch, I guess, my idea. I think we need to keep moving on this. We're not able to do it through the legislature, so what can we do through the regulatory process? Commissioner Hayward, comments?
Yes, I think it's good to get moving on that. And I agree with you. I think it's within our regulatory ambit, because defining expenditure is something we do, and so yes.
All right. So, Mr. Bainbridge, I know you have a lot on your plate. We tend to add things every meeting to your plate. This is something that I would hope perhaps we could have a follow-up discussion on in August, if that's possible with respect to your staff. And again, the idea would be to take the standard that we have already proposed through a legislative vehicle and determine whether we could adopt that standard through regulation to provide some clarity for the regulated public.
Yeah, sure. So the portion of the legislation you're obviously talking about is where we're defining what unambiguously urges means, I think is sort of the crux of the issue. And that's certainly within our jurisdiction, and we do it now. There's obviously parts of that legislation that we can't do by regulation, such as giving ourselves the authority to enforce the underlying violation or increasing the fine structure. But the definition of what constitutes unambiguously urges is something that we can definitely work on. And the legislation that we had proposed this year, that was actually the main thrust of that is trying to lay out clearly when we're talking about educational material and when we're talking about advocacy. So we can basically maybe present what the legislation is with the parts removed that we can't do by regulation and start from there.
Right. I think that's a great idea. And I know we had, before the legislature informed us they would not be able to move on that vehicle this year, we had spoken to a couple different stakeholder groups, including some groups that represent local governments. And so my hope would be that staff would continue through this process to engage with those groups, receive their feedback, and where appropriate, incorporate that into the regulatory package that we'd be developing.
Yeah, I had a call with the League of Cities just last week about this particular issue, and they're interested in engaging, and I think we have a common goal of making the line very clear as to what is permissible and what is not.
Excellent. All right. Well, I don't have anything further on this item. Commissioner Hayward, do you?
No, I don't. Thank you.
All right. Is there any public comment on our direction to staff regarding item number 6? Hearing and seeing none. We'll move to our final item. Last but not least, Mr. Wairinga, are you handling the legislative report today, or are we Mr. Bainbridge, or both of you?
I will have the duties today. Good afternoon, Chair Matich and Commissioner Hayward. Nothing significant to report other than what was submitted, with the one exception. There is actually one bill that is still alive and moving. AB 2151, the Gallagher bill with local campaign filings. We are getting mixed signals from the Assembly. As we've reported earlier, Assembly Elections Committee staff has told us nothing is going to get through, especially if it has any significant fiscal impact. And our analysis on this, the fiscal analysis, was asked for and provided to the Finance Department with the one-time cost of $381,000 and change, and ongoing costs of $360,000. However, in talking with staff from the author's office, and I do have to give an update that this is now on the Assembly consent calendar. It did move forward, and the author's staff feels it will pass the Assembly. So it is still moving forward, and we'll see what happens next week in the Senate, but I just wanted to give you an update on that. So the last line of the staff comments on number 4 there is outdated, and I will update that before the next commission meeting.
Excellent, thank you. And I see that on that bill, and I know Ms. Hahn is here and she can correct me if I'm wrong, but if that bill were to pass the legislature and be signed into law by the governor, there would be a fiscal impact on the agency. We would need, I think, 3 new positions, a one-time cost of $381,000, and then ongoing costs of an additional $360,000 per year. Is that correct?
That's correct, Chair Matich. We are requesting 3 additional positions for the implementation purpose and the ongoing effort of this legislation.
Great, thank you. Commissioner Hayward, anything for Mr. Wairinga or Ms. Hahn on the legislative report?
No, nothing. Thank you.
All right, thank you.
All right, thank you. Any public comment on our legislative report? Hearing and seeing none. All right, that concludes our June Law and Policy Committee meeting. Commissioner Hayward, care to make a motion to adjourn?
So moved.
All right, second, Ms. Linker?
Commissioner Hayward?
Yes.
Chair Matich?
Yes.
The motion passes.
Great. Thank you, everyone. See
Thank
soon.
you. Be safe.